Okay, everybody, let's get started. What we're going to talk about today is intellectual property. So that you can do assignment number 3. If you remember assignment number 3, that gives you a couple of scenarios. It talks about future of engineering management or engineering management in general, and competitive advantages, and remembering Porter's 5 forces model, and looking at the strategic plan and factors that go into it, which leads us to lecture number 11. So hold on a second, let me find lecture number 11. Here it is. Lecture number 11 of the MIT, or Management Information Technology, or Information Technology series, which is out here under the course materials, under the Technology Management. Number 11 is what we're covering today. And it goes along with that assignment. So the assignment wants you to use the Porter's 5 competitive forces and discuss certain things. And then there's some questions at the end of that assignment. And at the end of the assignment it says, mentions intellectual property. And it says, as an example here, I'll just read it to you. Can companies that develop and implement new technology projects themselves for competitors by seeking patents for their, can they do that by seeking patents for their design? Haven't really covered what a patent is. We're going to talk about patents, copyright, trademarks, and all that stuff. And how unique would it have to be to warrant something? That's kind of a guessing question. You don't have to know anything about the laws. A monopoly, talk about that. Outside of a patent, here's the other part of it. Outside of a patent, what can a company do to protect itself from its competitors? Which is what today's lecture focuses on that. And what are the strategies or ideas can you come up with to help a company better uniquely safeguard their copied, not be copied, essentially. So protecting people and information, threats and safeguards. Why in the world do you want to do any of this? Well, because first of all, just because you spent all the time and energy to develop a product, because you're engineering manager, you're managing a department, and all of a sudden your competitor is going to do the same thing for you, which not necessarily is a good idea. What ends up happening in the process is that you have to protect it somehow, and you're not knowing how to protect anything. You're not familiar with the laws because you're not a lawyer, so you're a manager. So you basically have to have a slight background in the protective mechanisms that are available so that you can apply them to the appropriate situation and make sure that the company is protecting themselves, because you don't want your competitors producing the same product that you're. There's too much talking in here. I don't know where it's coming from. Okay, thank you. All right, so you don't want your competitors coming out with the same product that you have and trying to use and piggyback upon your success, essentially. And then if they do that, then you want to make sure that you're protected as a company so you can come back and regain any lost revenue or any bad name or something that might be associated with it. There's revenue that gets lost because they're buying from your competitors instead of buying from you. There's also, if you're creating a product and they come out with something that's worse than your product, there's reputation damage. As an example, happened a long time ago with a bunch of super glues. Somebody came out with super glue, and it was great glue. And then we have fake super glues, strong glue, and then all of a sudden these glues didn't work like super glue because they were cheap imitations of it. And then people think that, oh, the super glue doesn't work. So what ended up happening was there was a big lawsuit that came back and said, well, super glue is sued, essentially. There is a super glue, and then there's a non-super glue. So it's like Q-tips and cotton swabs, different. And then you can sue, and if you sue, then you can regain market. Basically, it was a cease creating these bad products that make my product look bad, because people buy your product because it's cheaper and they think it's super glue. It's not super glue. It doesn't work the same way. It gives my product a bad name. And if that's a particular case, then we don't want you doing that. So not only is there a revenue as a recourse that might come out of that, some sort of a recovery, but there's also, don't do that kind of thing, slap on the hand, but, also prevent somebody else from ruining your company, essentially. So the student learning outcomes coming out of here, we're looking at ethics today, describing factors that affect and make decisions concerning ethical issues and ethical properties. Defining and describing intellectual property, copyright, fair use doctrines, and pirated software. And describing policies for privacy that describe ways in which it can be threatened in terms of privacy. and threats to privacy, things of that nature, and describing ways in which information on your computer or network is vulnerable. You know, we don't really have to go into a lot of that, but identity theft still happens these days. So there's about 96% of all American households, consumers 9 out of 10, largest credit card issuers, 20 million records, 110 million people, 96,000. There's a lot of people on the internet. There's a lot of information, and they make sales to customers, you know, merges and protects databases and a bunch of stuff. I'm going to kind of skip through the case study questions. Don't necessarily need to worry about that stuff, but let's just take a look here. Handling information responsibilities and understanding how the issues for ethics, personal privacy, threats of information, and protection of information. So technology breaks the rules, makes breaking the rules easier. It makes information available. So for the most part, as we grow through the economy in terms of personal use but also for business use, and we make products more intelligent, and we make information more available, and we converge things together, we put everything online, put it all on a cloud, we end up introducing ethical and privacy issues, not to mention copyright and intellectual property problems as well. And so these buzzwords are used up all over the place, but they all mean different things, but people use them interchangeably. And if anything, from things I've personally observed, people use the words in the wrong context constantly, and they have no idea what they're talking about, which is actually kind of funny. But long story short, these are all things that have come from the information age, and as a, working in a high-tech company, one of the biggest things you have to remember is that, especially as a management staff, you're going to be responsible for any problems that go wrong, and they're going to hold you accountable for the most part, because things always trickle up into management from a lower level perspective. What does that mean? Well, you have a group of people, and your people are stealing code from other people. You have a bunch of programmers that you're managing, and they're stealing code off the internet, or they're recycling something out of a book, or they're using an algorithm that's protected, or they're using something as open source but it really isn't open source, or there's a half a dozen problems that happen with that. There's also other problems in which you have people selling information or distributing information that they have access to, or using something, or putting something on their computer, all sorts of different things. So that's what basically the topic of today is, talking about those issues as well. Ethics. So something is unethical if the principles and standards that guide the behavior toward another person is wrong. So ethics have to do with people to people. So it's not unethical to take and copy something off the internet. They call that plagiarism, actually. Is it unethical? It is if the ethics is involved with you and the author of that person, of that article, whatever that you copied. So always say, when you think ethics, it's people to people. It's how people treat other people. You have ethical behavior, and then you have unethical behavior. You have legal behavior, and you have illegal behavior. Just because something is legal, it might be unethical. As an example, you go to Facebook and you discover that you'd love to upload your pictures. And so you upload pictures of your friend who just came back from Las Vegas, and this friend was dancing naked on a table at some bar, and you put it up on your Facebook account, and then the person gets fired from work or something because their boss is a member of their Facebook account, and they don't really like that picture. And then they're holding up a sign that says, "I hate the company I work for," or something at the same process. Completely unethical, however very legal. Happens all the time, actually. People put pictures up without using any discretion. That's, especially if it hurts it. If you've done a wrong against another individual, that you did it in the right way, it's unethical anyway. So that's what we're talking about in terms of ethics. Ethics are rooted in history, culture, religion. People think, it's unethical to talk to so-and-so about such and such. Or it's the whole ethics system is generally rooted with people, culture, history. Different cultures have different ethics, actually. In fact, it's really poor taste and unethical to show the bottoms of your feet, or to shake someone with your left hand, or to there's tons of business ethics that go along with business communications from different cultures and stuff. So, not unethical, however, to download it is unethical to download illegal content off of the internet. As long as it's unethical to the person who you're doing it for. It's illegal, but it's also unethical. But the act is not unethical. It's unethical because you're doing a wrong against the person who owns the copyrighted material. So anyway, so to keep that in mind. Factors for determination about how you decide ethic issues. Because lo and behold, as an engineering manager, you might end up one of these days having to figure out, well, what do I do? So actions and ethical dilemmas are usually determined by the basic ethical structure, context as well, and the circumstances of the situation. So it is essentially up to the management staff to determine what's ethical. Here's the unfortunate part. It's never in an employee handbook. It's never in a management handbook. It's always case by case. So there's really nothing you can't write rules and regulations. However, you can write things for guidelines. So it usually falls into the guideline category. So would it be unethical to take somebody else's source code and put your name on it? Yeah, technically. It's also stealing, but yeah. So your basic ethical structure determines what you consider to be a minor ethical violation, serious ethical violation, and then very serious. So you don't want to treat them all the same. So generally, most people would come up with a scale to say at a very minimum, you're at work, you're using the company's video equipment, and you take it home for the weekend. Not so ethical. Well, you borrowed it, but you didn't ask for it. Or you put up pictures of something that somebody else doesn't like in your cubicle or something. Maybe not be so ethical. So anything against another person is actually an ethical kind of thing. So basic ethical structure. We're looking at society's opinion, which might be different from individual opinions. Likelihood of the effect that it might have on somebody else. The reach of the results in terms of what happens with time to consequences. Putting something out on the internet is a huge issue because what ends up happening is it never goes away. So, which I'm kind of waiting for the new laws to come out on that. So right now people can post anything they want to post. But did you realize that individuals can actually sue other individuals for ethical wrongs? So the person who got fired can go back and sue their friend and collect, I think, about a year's salary plus some other dividend that comes in through their loss of employment until they find another job. And then if they find a new job and the job salary is less than what they used to make, they can get the difference recovered by the person who posted that picture. So if you have a lot of money, don't put pictures out on the internet and get your friends fired, because then they'll be suing you because it's unethical. And that's an ethical wrong. There's no law in the case book. There's no law in the legal system, but it's ethically wrong. So it's a tort crime. So consequences that might come out of that. So that's how you're gonna weigh the very serious versus the serious versus the minor ethical violations that might exist with that. So what I'm saying about ethics is that there's no steadfast definition of what's ethical and what's not ethical. It's all subjective. It all depends on the culture and the background. It's a person wrong against a person wrong. So it's people to people. And it comes in, and you should label it in different categories and not treat it all the same. Certainly would hate to be fired because you ethically stuck something in the refrigerator. You did an ethical wrong by sticking a meat product in the refrigerator at a vegan company or something. Ethically, you probably did a wrong there. Should you be fired because you accidentally forgot that everyone's vegetarian, or something, or whatever, and you put something in there that they didn't like, or you fed the cat of a vegetarian some meat product or something, I don't know. Anyway, long story short, you got to put it in different categories. Circumstances of the situation also come into place. Situations or consequences of the action or inaction. Inaction is actually kind of an ethical issue as well. You have a team of managers. One manager has a friend over at Google, and he discovers a bunch of stuff about the product, and he did this at a picnic that he was going to, and the guy disclosed a bunch of information, and then the person doesn't say anything. That's unethical, actually. Actually, that's actually illegal as well. But you have a right to disclose, or you have a proper disclosure kind of thing. But maybe the person didn't know about it, so it falls into multiple categories. But inaction, which means you didn't say anything, although you could have said something, you didn't say anything, and you should have said something. It's kind of like, when someone does something wrong, but you don't say anything, like Joe Schmo is robbing the cash register, and you know about it, but you don't say anything. You're as wrong as he is, which is actually kind of true. So society's opinion of also the action or the inaction, the likelihood of the effects, time of consequence, relatedness of people who will be affected, reach of results or the action. So that's everything I have on ethics, believe it or not. You can take an entire course on ethics. I think we actually teach it here at ITU. Business ethics, I think they call it. That's enough ethics, though. I'm just going to give you definitions. So I'm not going to give you an entire course on ethics. I don't know how you spend an entire 16 weeks on ethics, though. I can't even barely spend 5 minutes on ethics. And I'm not saying that it's important or not. I'm just saying you can't define it. It's like a wide open category of topic areas. It's kind of like engineering management, I guess, in general. All right, this is the part you're probably going to find some new information on, because most of you are familiar with ethics. So I'm going to give you the breakdown. And what's missing on this slide here is patent. So let me talk about patents first. Patents are on inventions. It comes from Patent and Trademark Office of the United States. The USPTO is what it stands for. United States Patent and Trademark Office. Companies who invent stuff file for patents. The patent protects their invention. So if they invented a chair and the chair has 4 legs, there is a patent on a chair, by the way. The chair has 4 legs. For 15 years, you can produce chairs, and you own that property, and that property falls in the category of intellectual property. Anything that's not tangible is intellectual. Tangible, something you can touch. I went to Subway's and I bought a soda. This is my tangible property. I am using a mouse. I bought at Fry's years ago. That's my tangible property. My bag, my computer, it's my tangible property. My right to drive a car. Well, no, see, what do I have? What do I have as an individual that's intangible? My knowledge, whatever I've gained in my head, experience-wise, is intangible. I own it. Which actually is a great idea. You know why? Because if I'm at a bar and I'm having a few drinks and I say, oh, you know what? I got this great idea for the chair. For the chair, yeah, it's got 4 legs, it's got a back, it's got a seat, it's got all that stuff. And somebody else steals it, that's a violation of my intellectual property. Because what I just said, what I'm talking to you right now is actually intellectual property. What I'm talking about, knowledge that I have, it's something I own, but you can't touch it, you can't see it, it's intangible. So in business, practically everything is possible in terms of the intellectual, which is intangible. So it's intangible creative work that is embodied in physical form. Usually for a business context, it doesn't have to be embodied in physical form. Usually the problems come into place when it is. So I go, and let's talk about me. I'm XYZ chair manufacturer. This is prior to ever being a chair on the market. I decide, I go to the bar and I start talking about my chair idea. Very next day I go down and I file an application and I get a patent on my chair. It doesn't happen that quickly, but let's just say I did that. And then I open up Acme Chairs Inc. or whatever, and I start selling chairs. The patent is my protection on my intellectual property, which was my idea of the chair. It was embodied in a physical form when I created the product. I put the product on the market. So then now I have our competitors are us, who also produced a chair next door. A company next door to me, or whatever, produced another chair, a different chair. Then I go, hey, wait a minute, you can't do that. So instead of us standing out in the street arguing, yelling at each other and back and forth, these 2 store owners yelling at each other, instead of that happening, I just go to the government and say, hey, look over there. And the government's kind of like the cop, you know. I go to a PTO office and say, hey, mine, this is mine. And they say, well, how do we know it's mine? Well, look, I filed this patent on it. Oh, it is yours. Oh, so it gives me rights to my own intellectual property, so that this guy over here, you know, stop selling those chairs. It belongs to her. Don't sell the chairs. So the government comes out and says, don't sell those chairs. Or if you want to sell the chairs, work an agreement out with me so that you can sell the chairs. That's what a patent does. It doesn't earn you anything. You can't sell a patent, although you can transfer the rights of a patent. So you can say, just like I discovered this chair concept. And I went, you know what, I know nothing about lumber. I don't want to make a chair. I'm a teacher. Why do I want to sell chairs? So, you know what, you want to make a chair? Here's a patent. Go make the chair. So then somebody else makes a chair. I give them permission. I transfer the rights over. Now they can have a battle with the person next door who's selling chairs. So all it does is protect your rights, and it protects your intellectual property rights. It doesn't actually protect the chair. The chair is the property. It's not the idea of creating the chair. So the chairs can be bought and sold on the open market, which is what people do actually. They make fake chairs, you know. It's like all you have to do is send a prototype over to China, have it reproduced a couple of times, you know. And then you take it into the US. You can buy a fake everything these days. Does it violate the patent? No. You buying it doesn't, but the person making it does. So that person is, you know, the source of the issue essentially, and that person is the one who's going to be responsible for it. So a patent protects the invention from anybody else using it. It only lasts for 15 years. It doesn't last forever. Actually, it depends on how long it's going to last in terms of when it was issued. But yada yada. It has a limited fixed amount of time to it. It only protects your right to use it. Well, to actually make product with it. You don't make product with it, you don't use it, it could actually be revoked. It could be taken away from you. Because it's not something you own. You don't actually own it. It's a right. It's kind of like your driver's license. Nobody owns a driver's license. Nobody owns software either. You have a right to use the software. So it's software protection. So yeah?
Would algorithms be intangible?
Certain algorithms as applied towards a particular utility are patentable. So unfortunately there's two types of patents. Well, there's three. There's a plant, a design, and a utility. It has to fall into one of those three categories. You have to imagine that the legal system existed long before computer science. So it has adapted to a certain point to take in consideration the utility of the algorithm. So if you wrote an algorithm that calculated out a traveling salesperson, and you did it fast, it's traveling salesperson scenario, and it made it twice as fast as that, yes, and as applied towards solutions to GPS programs, yes, that is patentable. If it's just a mathematical equation, not patentable. So it's, if you can perform math, not patentable. If you pick something out of nature, not patentable. If you have something that somebody else has already patented, not patentable. Can't spend too much. You have to take like maybe an entire semester course in intellectual property. In fact, I think we probably teach something here. We should teach something here on that. But there's so many different things that fall into the utility. Design is for arts.
Comes into copyright.
That's different. I'm going to talk about copyright in a few minutes. Yeah, source code can be copyrighted. Well, let me just get into copyright because I'm going to answer your question with that. Anything written is copyrightable. So it's not an invention, it's a copyright. So on your source code, you can actually just put on the bottom in a comment, copyright 1990, whatever, 2013, Barbara Hacker, yada, 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 for XYZ company. You put that on the bottom, it's copyrighted. You can register the copyright as well. So here's the deal. Let me just finish copyright, and then I'll go back and I'll explain something else to you. Patents, you have to actually apply. You apply for it. You go to the USPTO. You fill out an application. In the application, I'm sorry. You're going to do attendance?
Yeah.
Okay. Let me pause for a second here. Hold that thought. I'll come back. No, it's good. It's good. Okay, we're back. So let me go through this from the beginning. Not from the beginning, but let me just define these three for you. For a patent, you have to go to the USPTO and file a piece of paper called a patent application, and you fill it out and you tell them what your invention is. You define your invention, you talk about all the components for it, the utility for it, and then you get something that's issued to you with a number, and it says here's your number and here's your patent. It registers your idea with the government. This is the US government. Registers your idea so that other people, if they use your idea, you are protected. You can come back and say, hey, that's my idea. So it's for idea sharing and for inventions. You can also do the same thing with logos. So what I did is during the break here, I kind of bookmarked these pages for you. So the here it is, USPTO is Patent Trademark Office. So let me talk about a trademark for a second. A trademark is, a symbol that recognizes you as you. Like for example, that apple that shows up on all of your notebooks there, that's a registered trademark. It's registered because they went to the USPTO and they filed out the form, and they register it. When you register something like a patent and you register a trademark, while you're using it, you pay an annual fee to own it, and it says that you own it. So it's a way of buying intellectual property essentially, or renting intellectual property with your name on it, and it protects anybody else. So if I took that Apple logo there and I put it on some other computer, I'd be violating a trademark violation because of the logo. Or if I made a logo that looked like an apple but it was like slightly skewed or something, depending upon how different it looked, I might be violating a trademark. Trademarks are generally associated with corporations, so when you register your company, same concept. When you register, you file your articles of incorporation and you become a corporation, you fill out a form and you register, and you can register your trademark at the same time. Your trademark is, iPhone, iPad, iMouse. In fact, Apple used to own the I don't know if they own it anymore, which is kind of interesting because now we have a bunch of other stuff that came out, I write, I think, all this other stuff, the I, that has recently come out. So either the trademark has expired or they lost the battle with that. Who knows? Because for a while they were suing people who used I. Or E, ebooks, ePad, ePhone, I don't know. It was also at one point trademarked. So people protect it so that you can't come out with a bunch of iPads on the market. You can only have one iPad and it's owned by Apple or iPhone. Because otherwise you'd have multiple iPhones. Well, which iPhone do you have? I got one from XYZ company. It's different from the one you got from Apple. So that's a trademark. So trademark is on a logo or on a word. Generally it's a couple of words. It's not a lot of words. And it's something that associates your business practice with an icon, like a logo or like a word or something. You get that at the same office as you get your patent. So they're kind of related because they go along with your business. I'm in the business of selling chairs. I'm going to call it chair. And I could trademark the word chair. I don't know, what does chair stand for? I'm sure it stood for something originally. But because when we call them chairs, I don't know in English, but I don't know what the word actually means, chair. Well, like ball. How does a ball get ball as a name? It's round. How do you know it's a ball? So some names are generic, like that. Some names like Q-tips. There is a brand called Q-tip. The rest of them are called cotton swabs. A Q-tip is a cotton swab. But if you see the Q-tip, you know it's a cotton swab. But you can't put the word Q-tip on other brands that aren't Q-tip because that one is still trademarked. So anyway, long story short, the trademark protects the brand identification, like Levi's or the name of it. You just can't call it Levi's or Timex. It's the name of the company, but it's also the trademark. It's a Timex. Anyway, so if we go to another common source of information is from you. So this is the bookmark. It's uspto.gov. Everything you ever wanted to know about patents and trademarks. Going back to the lecture here, the one underneath it is a copyright. So as I mentioned before, you can copyright something by putting copyright on it, along with the date and your name. Copyright by Barbara Hecker on, or at something, 2013 and the date. Believe it or not, it's protected at that point. If you want to have other people recognize it, you want to register it, you can register the copyright. So people who write books send the books and they get them copyrighted. Fill out a form, you go to this website here. None of this actually takes that much of a legal experience, nor does it take an attorney. However, attorneys are in the business of helping people who don't want to bother with this to do it for you. But people can actually do this themselves. So you go to copyright.gov and you come in here and you fill out a form. It's actually even easier. It's much easier. The patents are probably the hardest. Trademarks are the second hardest. Copyright's probably the next. So it's about third down in terms of complexity. Anyone can do this one here. You just fill out a form. You give them a hard copy of it, or you email it in, depending upon how you're doing it. You say, hey, look, I wrote this poem. So what can you copyright? Anything that is written. Copyright's writing. Non-writing graphics is trademark. You can't trademark, you can't copyright a logo. You trademark a logo. You copyright a writing. Source code is a writing. So going back, I'm actually trying to answer your question still here too. You can copyright your source code. If you copyright your source code, people can't copy your source code. They can't make alterations of your source code either. When you plagiarize, you violate copyright restrictions. So when you have taken something that's not yours and you treat it like yours by cutting and pasting something off of the internet or something out of a book, you know, opening up a book and saying, just typing in what's in there, you've basically participated in what's called copyright infringement. You're infringing on somebody's right to own those words in the way that they expressed it, and you're taking their thoughts or their expression and you're stealing it. They happen to have another word for this called plagiarism. It is also a violation of copyright when you make reproductions. So you take a book and you say, hey, you know, this book's really expensive. Would you like a copy of it? And you go over to the photocopier machine and you take a photocopy of it and you give it to your friend. You have violated copyright infringement. If you see on the bottom it says, reproduction or printing of this book, blah, 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 is copyright infringement without permission of the author. It's a wrong against the owner of the copyright. The owner of the copyright is the author of the who's actually written that expression. It's not Pearson's Publishing or whatever publisher was used to publish it. It's the person who actually came up with the words that you're copying. So that's kind of an interesting thing. People violate copyright infringement all the time by uploading something to an internet. Yeah?
Can you copyright logic then?
You can copyright logic, yes.
Logic as well?
You can actually patent logic. You come up with a new concept for how to make a program and how to do it. You know, let's say you invented object orientation, you know, or a better form of object orientation or whatever. You can actually, if there's a utility to it in the creation of other source codes, and if there's value in the terms of uniqueness for its utility to apply it towards solutions, it's patentable. If it's just a program that you wrote with it, it's copyrightable. Software can be copyrighted all the time, actually. Which is why if you're a programmer and you write software for a company and you put your name on it, technically it's copyrighted. When you turned it in, you get its ownership of the company. You go to another company, company A, company B, you go to company C, and you write the same source code for them, you've participated in copyright infringement. Or you've committed for copyright infringement. So they can legally go back and sue you because you gave somebody else their intellectual property transferred from company A to company B to company C. That's against the law. That's really big, actually. You don't want to do that because that's how stuff gets spread. And long story short, you probably have signed as well a non-disclosure agreement. So you're stuck both ways. Because copyright is very hard to enforce. Non-disclosure agreements, much easier to enforce. It's right out there in black and white. It says you are aware of the fact that you copied something that wasn't yours. So a lot of people say, well, I didn't copy it. I didn't bring anything with me. But it's in your head. And it's the intellectual property that you copied. So you took the intellectual property of the idea that you heard about over at company A that you wrote the source code for. You took the concept and you implemented it at company B. You have committed intellectual property fraud, or you've committed copyright infringements and fraud. That's what happened with Facebook. So the guy learned about it over here. He goes and implements it over here. Well, the original inventor of this idea, even though he didn't do anything to create Facebook, he didn't work as hard, didn't do anything. He still collected most of the revenue that came out of it because he's the owner of that intellectual property. So intellectual property attorneys, which I want to be actually one of these days in the future, they're the ones who settle the disputes between the people who have copied, and you show that they have copied and where it came from and when did they get knowledge of this and how did they obtain it and all these little things it goes through. It's kind of a tedious little battle, but in the end it protects people with their rights for their own inventions and their own ideas, essentially. And there's a whole body of law that goes along with that as well. I can't give you everything. I can't give you 3 years of law school in 1 hour, but there's a lot of stuff that goes into that, long story short. It's a pretty big area of law. It's very popular out here in California, however, as well, because it happens a lot out here. Technology gets copied on a daily basis. And as I was mentioning before, you go and you download a PDF file that you got from a BitTorrent, and it's on your computer. You didn't make the copy, but you got the copy. That's unethical. Is it illegal? It's illegal to make the copy and distribute the copy. So there's a fine line, and the legal system quite hasn't figured it out yet. So eventually what's going to end up happening is they're going to catch up to the electronic world eventually, and it'll be deemed to be illegal. So it's illegal to make available copy-protected or patented information, right? Or not patented information. Patented information is actually given away. So we have another thing called a trade secret that is also registered, but it's hidden, it's private. Example, the trade secret of the Kentucky Fried Chicken secret recipe. That's a good example. That's a trade secret. Microsoft's, a lot of their source code is trade secret. A lot of that build not open source, not available. That's a trade secret. So a trade secret is something the company owns as intellectual property that's not public and cannot be made public. Anyone who makes a trade secret public violates the trade secret. So trade secrets are violated all the time when people, oh yeah, I saw that. Yeah, it's blue. What? Then I've just committed, and this copy of the color was blue or something. That was the trade secret or something. Or, oh, the Kentucky Fried Chicken, it has a salt, sugar, and, I don't know, corn husks or something inside of it. If I actually gave away the trade secret, verbally or written, then I'm committing trade secret violation. Patent is not a trade secret. Patent is open to the public. Patent, when you publish a patent and you make that available, what ends up happening is you protected your idea. Now you're disclosing it to the entire world so that the entire world can learn from it and move forward. I just want to make sure I put this to resume it. So the concept of the patent is actually share your innovations, because the system comes down to the earlier, Abraham Lincoln, who patented everything. That guy patented everything in the world practically, but it made things aware so that we could grow and research, and we could share research with other people, and we could essentially expand as a country and expand as a nation to learn from everybody else. So patent is the exact opposite of a trade secret, actually. So a lot of people think patents are, oh, it's patentable. Oh, no, it's not a secret. If they patented, they disclosed it. They made it aware. It made everybody aware of it. Trade secret, opposite of that. Trade secret, you never want to disclose that one, because then you could be violated. You could be violating a trade secret by even mentioning that something. So this is where the non-disclosure comes from, which is kind of interesting. So you sign an NDA, a non-disclosure agreement, to protect trade secrets. It doesn't protect patents, it doesn't protect copyright, it doesn't protect anything else, just trade secrets. So you are exposed to, okay, come on into the green room. We're going to show you how we make things green. It's a trade secret. Here's a non-disclosure on it. Come on in. And then you leave the green room and you tell your next door neighbor about the green room and everything that's inside of it. You just violated non-disclosure agreement. If the non-disclosure agreement said you're not supposed to say anything about the green room. If it didn't mention the green room, non-disclosures doesn't really matter. You didn't disclose anything in the non-disclosure. They came up, non-disclosure is like the 20th century protection of the trade secret, because trade secrets can't be enforced, or they can be enforced, they're just harder to enforce. So people came up with this blanket non-disclosure agreement to protect themselves. It's like when you get car insurance and then you get personal liability insurance on top of that. Just in case my car insurance doesn't work, I'm going to have extra added bloom. Just in case everything else doesn't work, I'm going to have another insurance. Or you get multiple health insurances because, you know, one of them is going to cover and the other one might not cover, you know. People do this all the time. That's how companies treat non-disclosures. Also, the non-disclosures will catch you all for anything that's not protected in any other way. So if you're worried, did legal file the document yet? I don't know. People, you can write this off the internet. You just download a non-disclosure form and you fill it out. You put the names and the date on there and stuff. Please do not talk about, you know, you may not talk about the green room. Here, sign it. If you talk about the green room, you have violated the non-disclosure. Easier to settle that in court. Then, did they file the trademark yet? Did they file the, is this a trade secret? Trade secrets come in many different forms. Not every one of them is registerable. So, a recipe is registerable. This is how we run our classes at ITU. Not necessarily something that you can protect in any other way. It's a trade secret, so you have to sign a non-disclosure if you want to get out of that one. But long story short, there's different categories, and I'm giving you a big picture summary. I'm not giving you all the law that's associated with it. That's why I'm showing you these websites. So if you're interested in trade secrets, that's on the USPTO office. Copyright, anything that's written is copyrightable. So there used to be an old thing where people, and it still sort of works a little bit, you got to show the date that you wrote it. So if you wrote some source code, going back to your example, and you wanted to protect it, what they used to do in the old days is send it to themselves. You know, you write it, you sign it, you put it in an envelope, and you send it to yourself and keep it. Keep the sealed envelope, because it proves that you wrote it on that date. And then you don't have to register it. But most people would register it anyway. You just go to the website, you fill out a form. It says, I wrote this book, it's called How to Program in Java. Okay, here it is. Let's copyright it. And what it does is it takes a copy of the book, takes your form you filled out, puts it together, and puts it on the website, or puts it in the database. So you can put the copyright on this date by so-and-so, which means it's a please stay away from this. Please don't touch this. Don't copy my work. Is what it says. And then because if you do that, then you go to court and say, hey, look, I copyrighted it, it's mine. And then you can say, well, what can you sue for? Damages that are associated with it. Book companies are serious about this one, and I'm waiting for legislation to come down on this one. All those PDFs you get out there of books, that's copyright infringement because somebody made an illegal copy of it. Right now it's kind of unenforceable because it's all over the place. What's worse is when someone changes something. You take copyright material, you reproduce it, and then you alter it, so it's not even the original anymore. Then you got damages. If you're the original owner of that, you're like, hey, wait a minute now, that's not my super glue. Don't be showing it like super glue when it's not super glue. And then you have something to sue for. So long story short, there's a ton of illegal stuff on the internet. Music is also protected as well, music are associated rights. So it's not reproducible, it's copyright infringement. So, which means if there's a song out there, there's an audio recording, a video recording, a written recording, because copyright is on words, can be spoken, can be written. Anyway, so in written communication, spoken communication, expression of art. And there's a big old category that all these things fall into. But and long story short, go to the copyright here, and you can see all of the different categories and all the different things that you can possibly copyright. Let's talk about websites for a second. Let's talk about Creative Commons. So here's where you can really protect your stuff. So you can go to Creative Commons for free, and you can license make things public domain. Figure out, oh, I have this source code that I wrote. I don't want to copyright, but I want to protect it. Because I don't want someone taking my source code and putting it into a commercial application. Because I wrote this really good encryption algorithm, and I want it to stay open to the public. Then you go to Creative Commons, and you can protect it this way. So you're making it so that it's an open source license. And you put the restrictions in there. You must include this with it, like GNU. This is the grassroots way of protecting your art, protecting your source code, protecting your website, protecting your images, your graphics, anything you want from reproduction, generally over the internet. So copyright goes all the way back from the beginning with photocopying and people using those words. Creative Commons is more for electronic communications. Electronic, you know, I have this blog. Don't touch my blog. Well, go to Creative Commons and get, you know, a license for that. Basically, you're just saying that this is mine. Don't touch it. I have a Dear Abby Dear Abby. I have a Dear Abby column. You know, how many other papers have Dear Abby? Nobody does. They have Dear Barbara or Dear Jane or Dear something. They're not going to have Dear Abby. That's protected. So, how do you know it's protected? Well, you can actually go to these different things. It's a trademark, actually. You can go to these different resources and discover what it is. Depending upon what it is in the area of intellectual property, it falls into the different categories. All of this stuff is intellectual property. It falls into different categories. There's different levels of protection for each one of the different categories. This is probably the most confusing thing in terms of protecting in an organization, which is kind of odd. So there's also this fair use doctrine. So we have fair use, which basically says we're going to give it to you, but you have to use it the way I want you to use it. So fair use is associated with copyright, is when you write to the author and say, I really like your book. Can I make it available to my students? And you sign what's called a fair use agreement that says, yes, you may, but you're not allowed to alter it. Okay, that's fair use. I'm using it, but I haven't altered it. And then I decide, you know what, I don't like that chapter. I'm going to rewrite that chapter, and I'm going to give it to my students with my chapter. Chapter 5 is going to be mine. You've violated the fair use policy. If you violated the fair use, you've violated the copyright agreement. Violate the copyright agreement, the author can come back and say, hey, do not distribute that book anymore. I know I told you it was okay, but you violated the rules. So you violated the fair use. So you're a company, you come in and you get hired on day number 1, and they give you all this business equipment. This is usually where this comes into. It's called fair use, where you sign it. You know, they give you a whole big stack, 20, 30 pages of documents to sign when you join the company. You sign on, okay, fair use, okay, good. Information technology, okay, good. You sign all this stuff. And then you're taking a lunch break, and he's like, let me check my Facebook real quick here. You go online, you check Facebook, and then 2 minutes later, an hour later, you're fired. What? You violated the fair use policy, and on the bottom line it says underneath it says you may not check social media websites from company computers. What? I can't believe I got fired for that because you violated the policy. You signed for the policy. So a lot of people don't even read that stuff, but be careful. Also, there's other acceptable use policy, which is different from fair use policy. Acceptable use means that you're accepted to use this computer for business purposes only. So as an example, you have a cell phone. You assign an acceptable use policy for the cell phone. If the company's smart, they have this accessible use policy. It says, can't have business calls, you can't do anything, you know, you can't use it for calling out of state, you can't do it. Any other restrictions that say it's acceptable for you to use this phone or this computer or this laptop or whatever in this particular manner, which means you can go to Facebook on it as long as it's for company use. You know, you can do that as long as it's for the company use, depending upon the use of it, which is acceptable. And they have a list of unacceptable behaviors and acceptable behaviors. Versus the fair use, where you may use copyrighted material in certain situations. You may use stuff. So the fair use and the acceptable use are 2 separate documents or 2 separate agreements. They both overlap because most companies will go, fair use policy. Well, you're using company-related technology and intellectual property while you're at the company. As an example, if I use the ITU logo, I don't own the ITU logo. It's a registered, hopefully it's a registered trademark. If it is it should be a registered trademark. If it is a registered trademark, I can sign what's called a fair use policy and use the logo on all my letterheads and all my correspondences that I'm doing with students and with letters of, recommendation and all the things that I would use the logo for, and it would be acceptable use. And then I can have usually for acceptable use is associated with computer technology. So acceptable use policy is if ITU issued me a laptop and they said you could use it for just your classes, don't install any software on it, don't do anything else, that's an acceptable use. So, unfortunately, there's a lot of gray area between the two policies. So usually there's both policies that exist. And the fair use goes beyond a company-employee relationship. Fair use applies to anybody who creates anything out there. So you write your own source code, and you decide you can come up with a fair use policy and include it in with your Creative Commons open source license, perhaps. And then anyone who doesn't use it correctly, you can prevent them from using it. Say, you know what, you can't use this anymore. And if they do use it, they owe you, they'll have some legal recourse to stop them from using it. So, many different ways of protecting information. And it all falls in the example of intellectual property. So using copyrighted software without permission violates copyright law. Pirated software. Pirated software, by definition, as I say, there's a lot of overlap with all this stuff. The unauthorized use, duplication, distribution, or sale of copyrighted software. You don't want to sell copyrighted software. That's pirated. So generally, unfortunately, most categories now have come down to sale. So they call it pirated when you bought it or you obtained it from somebody else. Then you have gotten pirated software. But you haven't pirated it yourself, but you got it from someone who did, which means it's not yours because it wasn't obtained legally. So it might be ethical, but it wasn't legal. It's very ethical to go to one of those download websites that's open to the public. What's wrong with that? And some of them, like, you know, one of them actually was called Napster for the longest time. Kids went to it all the time, peer-to-peer. Very ethical, very mainstream, actually, for the at the time. And then someone decided, you know what, this is illegal. So why is it illegal? Said, well, because they're just sharing it. It's not for commercial use, but you're still sharing it. So then, you know, it's like if you make a copy of something that you purchase or you obtain a license to use it, you don't actually own the copy. So you can't make another copy of it. So it violated so many different problems. People still don't understand it. There's a lot of mainstream people out there that just download stuff all the time. Or better yet, try uploading something to YouTube that's copy protected. You'll find out immediately, and then your account will be closed. Don't want to do that one. So I haven't done that one. So, but I've heard of people who have done that one. But I always run into stuff on YouTube that's illegal. You want to know, where did I get that? People used to go into movie theaters, and then they record the entire movie, and they put it on YouTube, or concerts. You can't record at a concert. It's intellectual property. The artist who's up there singing the song, you can't steal that. How are you stealing that? By making a copy of it on your cell phone? Holding your cell phone up, pressing record, you're breaking the law, actually. Now they're just suddenly trying to figure out that it's a problem only because it irritates everybody else around you. Until it started irritating people, people never really cared. It's like taking a picture. You go into a museum, you pay admission to go into the museum, you paid to see what's inside of the museum. You take a picture of something in the museum. Well, in other countries, you go on vacation, you take a picture, you'll be handcuffed and sent out of the room. Well, maybe not handcuffed, but they're pretty strict. The U.S. is pretty lenient. You go over somewhere else and you go to a museum, you go to Italy and go into the museums, they'll hold a gun to your head and say, get out of here now. You can't, they'll disown you from the entire museum, throw you out. If you, just because you have a camera out, you can't take pictures, you know. Otherwise, if you took pictures, nobody would come in. So the idea is, you know, no one's going to want the original if they can get a copy. So, and plus, they own the copy. They own the original. They're not authorizing you to make copies. So, more and more these days, there's a definite crackdown on it. So, piracy, the right to let alone when you want to be, privacy, to be alone when you want to be alone, to have control over your own personal possessions, and not be observed without your consent. Privacy is also another issue that comes up on the internet these days. Usually with social media. As an example, when person A took my picture, not my picture, took, I don't know, that other person's picture. Remember that woman who went to Vegas when she was dancing on the bar top naked? When that picture ended up on the internet without the consent of the person who's in the picture, it was a privacy violation. And a privacy violation is another act in which you can actually sue for recourse. So don't take any pictures of your friends that they don't want out on the internet. Don't put them on the internet. You put them on taking the picture is not a problem. Sharing the picture is a problem, especially without their consent. So how do you get their consent? Well, you have to have them sign a legal form that says, I give you permission to put this picture on Facebook. Happens all the time with companies, actually. In fact, you guys might have even been part of this. Who knows? No, actually you haven't been, because they're pretty protective here. You go around and you take pictures of students, you know, at events and things. They don't do that anymore, which is good. They used to take pictures all the time, and then the pictures would show up on the internet. I don't want a picture on the internet. I don't want this to happen. You know, so you could sue for privacy violation. You invaded my privacy. And you invaded privacy, that's pretty serious these days. So, because the internet and everything, right? So, long story short, don't do that unless you get permission. You get permission, get it in writing, because just because someone said, yeah, I can do it, the next day, oh my God, did you see that reaction? No, don't do it. I didn't want you to do that. And they changed their mind. So, yeah, don't do that. So, it's not good. Happening a lot with individuals these days. Happening a lot with, well, actually, one of the biggest issues happens with, it's not the bullying, but there's another situation that's going on with, okay, so teenagers should not be on the internet anyway. But teenagers are on the internet. In this country, it's a source of ridicule, peer pressure. It's really bad. You get a bunch of juveniles who are not adults, who are, if you think bullying's bad, what about people who commit suicide and they're only 12 years old? Because so-and-so put a picture, you know, the pranks that happen in high schools these days, and then they record it, they put it on the internet. Well, the families of these people that caused their son or daughter to commit suicide are getting sued. Because it's a violation of privacy. Why did you put little Johnny's picture out there? They're blaming the people. They're holding more people accountable for this, which is excellent, because then it stops it completely. There's no need for that stuff to be on the internet, to be public, but they don't know that because they're just teenagers. So, unfortunately, there's a lot of teenage suicides, teenage deaths, teenage stuff that goes on because they're not adults. They don't think right. They're not mature, and then they see a picture and it's horrifying. It's horrific. And then they don't, you know, they end up committing suicide because there's a picture of them kissing a dog on the internet. And it could be something, you know, like small like that. Actually, that was something. There was a kid who kissed a dog. It was a French kiss. It was a pretty nasty kiss. The kid committed suicide because his friend put it out on the internet, which I think is pretty sad to begin with. But anyway, long story short, that was an invasion of privacy. The parents of the kid spent out about $5 million in damages, which is pretty much all they had. It broke them completely. But it was their daughter, or their son. No, I think it was a daughter. It was a girl. It was their daughter that actually did that. So the parents, under 18, parents get held accountable. They pretty much took the parents for every dime they owned, which is good. Makes a point. But at the same point, why is that happening? So, dimensions of privacy. Psychological dimensions, to have a sense of control. Legal, to be able to protect yourself. If a company took your credit card and put it on the internet, that'd be invasion of your privacy. So, privacy and other individuals. We have keyloggers, key trappers, and software. Spyware, actually, is an invasion of your privacy. But people don't even realize that half of you guys, well, not half of you, but your average everyday person who installs these things, and they get the toolbars. Yeah, I want the toolbar. It's just spyware that you agreed to. But because you agreed to it, you're agreeing to having your privacy violated. But you don't, if they said, we'd like to spy on your emails. If it's okay with you, click yes. That would be a lot more clear than, wouldn't you like to have the such and such toolbar installed as well? Sure. That would actually be a better solution. So, but Keylogger is a program that when installed on the computer records every keystroke and mouse click, screen capture programs. Email that's stored on many computers travels to different senders and receivers. Actually, there's a newer technology now that works with mechanical devices. I think I talked about this before. The credit card scanners, the grocery stores. That's still happening, actually. You know, they install this little magnetic reader on the card reader. What's a card reader? It's supposed to read your card. It's not supposed to save your data, but it's supposed to read the card. And then, you know, that's invasion of your privacy, actually. Hardware keyloggers, event data recorders. Actually, it's illegal to record a conversation without telling the other person you're doing it. So, because you have intellectual property, remember, everything that's in your head is intellectual property. So if you're talking to somebody, hey Joe, come over here for a second, I want to talk to you. And he's recording your conversation, and then you figure this out, he's violated your privacy rights and has committed intellectual property fraud or, you know, violations at the same time, depending upon what you're talking about. But also anything that comes out of your mouth, like the dog ran down the street, is intellectual property that I own. That my knowledge of the dog running down the street is my intellectual. It may not be of any value to anybody, but I still own it. So it's against the law to record somebody's telephone conversation. It's also against the law to record anybody face to face, believe it or not, actually, without telling them. And you don't necessarily have to have their agreement. You just have to let them know that you did it. So, but there's many different laws associated with that. So I'm giving you a summary. Not giving you all the details of this law. So. Email is one of the most interesting and the most copied forms of communication everywhere. And as I was mentioning before, there's no expectation of privacy on the internet. So, in fact, usually your ISP account has an expectation of privacy agreement that says, our server is storing all of your emails. In fact, I don't know, I've never read the Google agreements, but I'm sure there's some sort of a privacy disclosure in there, yeah, that says, we're not responsible for anything that you may have lost, which means don't give your credit card numbers out in an email message. Don't give out your intellectual property if you don't want it out, because the providers are not going to be protecting anything for you, and you're signing a disclosure that says they're not going to protect anything. But email is copied all over the place, housed all over the place, backed up all over the place. Company email is even worse. You write a message on a company email machine, and the company email gets read by the IT people. Actually, it doesn't. A computer system goes through and scans it for stuff. You know, like people's names and stuff. They're trying to do data mining on who's talking about what, code names for projects, make sure people aren't talking about what's going on, stuff like that. And what ends up happening is, you know, you did this on company time, so you violated the fair use, the acceptable use, and now the privacy, privacy laws that were associated with it as well. So long story short, there's no wrongful termination on that one. So, identity theft. This is actually why make calls when a computer can do it? Yeah, true. I like that. I never saw Identity Theft, the movie. Somebody told me it was good. So, I always think of that commercial here with Peggy in Alaska, credit card. It's like it's just, 70 or 60-year-old guy, and he goes, "Hello, this is Peggy." And you're like, "This is not Peggy. Like, you don't look like a Peggy." So, major categories of identity theft. Credit cards are still pretty high. Phones, utilities, bank accounts, employees, government docs, and benefits. And you might look at this and go for a second here, well, what makes some categories higher than others? It's the percentage of time that you're using it over the internet. So, credit cards are going to be used over the internet a lot. How are you going to buy something? Well, that's why people like PayPal, actually. But phone bills with cell phones and utilities, nobody checks it. It's used by multiple people. So banks also used by multiple people. You get down into here, how's it hard to fake another employee? Very hard. To collect employee benefits for health insurance? Happens all the time, actually. They send the child in on the parent's account under the same name, same last name, and they just first initial. And then they go, oh, who got that? Why does my employee need pediatric care? Wait a minute now. He's 95 years old. No, or 85. I don't know. Government documents, oh, they're going to crack down on it. Loans, pretty hard these days. So, risk of identity theft across the states. And this is between the bigger bubbles or the bigger states. Obviously, we're high-tech in California. Florida's got a bigger problem now. Florida, Midwest. So, well, this is from about, I don't remember what year this is. I'm sure it's changed a little bit, but it's on the coast for the most part in terms of individual cases of security breaches. Not to say that can't happen to somebody in here, but these guys really aren't interested in the internet these days. So this is the Midwest, not so popular. Some of these people don't have home telephones yet. There are still people in the world who do not have a landline or telephone service. I thought that was pretty. I saw that from a government statistic. So, and it's all in the Midwest. So identity theft. Identity theft, by definition, is the forging of someone's identity for purposes of fraud. Now, can you forge their identity for non-fraudulent purposes? Sure. Is it identity theft? No. Unless there's fraud associated with it, not identity theft. It's impersonation. So it happens at Halloween all the time. People impersonate other people. Not identity theft. But you look like them. So, let's see, carding. I can never say that name. Phishing, brand spoofing. Actually, yeah, people do that with URLs all the time. Domain names, they spoof it. So instead of www.the White House, it's White House. There's a one with White House. There's a whitehouse.org and then there's a whitehouse.com or something. I'm not going to Google it, but if you do, you get some pornography site that comes up actually with White House. The White House, like the government White House, you misspell it. Or some words that where you flip the two numbers, the I and the E. So what a lot of companies have done is they've bought the misspellings. You misspell. I wonder what G-O, take one of the O's out, G-O-G-L-E comes up with. And I'll probably Google. Huh?
G-O-G?
No, take out one of the O's in Google. Or Yahoo. Yahoo had one of the O's in Yahoo. So, and long story short, they don't spoof it. They just make it. They buy the domain names that are all the matching combinations of misspellings. Barnes and Noble has a really bad one. It's still out there too. And I always mistype it when I type it in. And if you do the common mistyping, you'll bring up to this website. Well, there's one for eBay too that works funny because these are companies I go to all the time. That's how I know these. And the eBay, it's actually a bookstore. No, eBay is actually an auction house, but it's not eBay. But it looks like eBay. That's against the law, by the way. It's not identity theft, however. It's brand spoofing. A technique to gain personal information from proposed for the purpose of identity theft. Well. Or to sell a product or to gain somehow from a spoof, or not real. Also, there's people who spoof IP addresses. So you type in something and you put something out there that catches it, that basically takes it to another site. So you think you're going to Barnes & Noble, but you're not at Barnes & Noble. You're at fake Barnes & Noble. But it's not Barnes. It doesn't happen with Barnes & Noble, by the way. However, it has happened in the past with some servers who don't have access to the domain name server correctly, or have fraudulent domain name server information put in there. So it thinks it's going and it reroutes it to the wrong server, essentially. Never reply without question to an email asking for personal information. We all know that. You'd think we all know that. The reason why this still goes on is because people still fall for it. The classic is the PayPal with the PayPal logo. It looks like PayPal, but I don't have a PayPal account. You know, and why does my school want me to put in my email information? Well, yeah, then you get it's because it's basically not they're phishing essentially. And don't even say leave me alone. Don't say leave me alone either. Don't reply, because then if you reply to say take me off your list, you get put on the list because now you're valid. It's like send me a response. Let me know this is a real address. Was what it should say instead of. Because some of them will actually put, this is the newest scam actually, or not new, it's been around for a couple of years, unsubscribe me. If you have never subscribed to this, never press the unsubscribe. Because you have subscribed with the unsubscribed. Alright, I don't have to tell you about identity theft. Farming. rerouting your request to a legitimate website to another site that's not so legitimate, sending it slightly different web addresses, or by redirecting you after you have already been on a legitimate site. Accomplished by gaining access to giant databases that internet providers use for routing web traffic, domain servers and stuff like that. Often works because it's hard to spot the tiny differences in the website addresses. Actually, that's an interesting thing, because what you can do is just look at the end. You'll see a lot of, if it's an education site, it should say edu. You look at it, it says .com. Don't even touch that website if it says .com on it. Which is a lot of the email stuff that comes out and says, your website administrator would like you to change it, and it's a .com. But it's itu.com or something. I'm like, no, that's not going to be right. Piracy and employees. Companies need information about employees to run their business effectively. So 2005, 60% of employees monitored employee emails. So you can monitor emails, and that's legal. You can record duplicate hard drives, that's legal. You can even remote connect to people who are at the company to their computers, and that's legal. So 70% of web traffic occurs during working hours, so that's when you're going to find out all this stuff. 78% of employers reported abuse. Yep. 60% of employees admitted abuse. Yep. How did you go to, you went to www.southwest.com. No, you just ordered a flight. That's a problem. So, cyber slacking, the misuse of company resources. I don't know. People don't use cyber slacking as a word anymore. Visiting inappropriate websites, gaming, catching, stock trading. Reasons for monitoring: hire the best people possible, ensure appropriate behavior, avoid litigation. There was one recently, I shouldn't say recently, about 10 years ago, before all this stuff started, where a guy went on a neo-Nazi white supremacist website during working hours and posted stuff from his company computer during working hours on company equipment. They traced it back to the IP address of the company, and then the website sued the company. Because the guy's working for the company during working hours, posting stuff that was defamatory on a hate email, a hate board or whatever. Long story short, the company ended up paying out big bucks of money, tried to fire the guy, fired the guy. Then the guy took him back into court and sued for wrongful termination and won. Company just got screwed over. He won because there's no fair use policy or acceptable use policy. And there was nothing to restrict him. And he went to a valid website and posted valid comments on a freedom of speech board that he felt he was doing correctly during company times. And the company was essentially paying him to do that. So long story short, after those landmark cases or high-profile situations, well, it's like the Napster thing. They had a couple of mothers. They sent $50,000 fines because of their kids. That stopped immediately, but that made public media. All of a sudden it's like, what? You're going to pay $50,000? There goes his tuition money. Because he went and downloaded Madonna CD or something. It was one Madonna CD. It was for $50,000 or something. Because the guy just redistributed it out to like tens of thousands of other people. This was back in the Madonna days. But long story short, it takes one or two things, and then all of a sudden we have new rules, which is what the government did actually after the neo-Nazi guy. He definitely made an impression upon companies. So. Piracy and consumers. Customers want businesses to know who they are, but not too much. Well, no one should ask you for your social security number anymore. So as of about 2005, 2006, we have the government's acts that started. So companies can't keep more than 2 pieces of information, and they can't keep the full social security number on you, and they can't keep the information longer than their intended use. If they keep the information longer than their intended use, and they are discovered through random audits that they have it, then the company gets fined whether or not there was a problem with it or not. So it's basically making the companies more accountable for this stuff. Unfortunately, it's an inconvenience for customers because you can't keep stuff in there anymore. So even those websites, which is actually kind of interesting because Amazon, you can store your credit card information as long as you sign an acceptable agreement that says that you're storing it and you're allowing Amazon to store it. And then you have 2 options. You can store it completely, or you can store it and require this 3-digit code from the back of the card. So I always pick that option because at least I know, I just memorize the code. I know the code, and I know that's not going to be used from some random internet bot that goes by and purchases for me. So without anything, you just press a button, pay now. Okay, we're done. Nice convenience, not so safe. So it's also, well, they don't have the don't call. They used to have a don't call list. Now it's against the law because it's an invasion of privacy for a company to call you at home. So, which is kind of interesting because it still happens, but mostly with charities now, because charities fall under a different. It's not for a consumer. It's not to sell you something. It's to get you to donate something. So, let's see. We don't have cookies anymore, do we? You guys know about cookies? Web browsers don't let them happen anymore, but for the longest time, it's a small little piece of text file that gets stored on your computer in your web browser. Think of the past, because a lot of web browsers turn them off completely, or a lot of antivirus programs would eliminate them. But cookies were the longest thing. Actually, they were for good in the beginning. It just made it so the website would remember you. Unfortunately, everyone has to ruin a good thing, make it bad. So they tried encrypting cookies for a while. That didn't work. So people just don't use cookies. Cookies is basically allowing a server to access stuff on your computer, opening it up. Not so good. Well, it says the same thing with some of the original instant messaging programs that opened up ports. Not so good either. Those have all been fixed. Spam. We still get spam? I still get spam. Ends up in my spam mail. When will spam ever go away? It's never going to go away. Unfortunately. Unsolicited email. We all know about that. What the biggest thing now is they want you to click on something. Actually, if you get a piece of spam mail and you think, oh, it's for, let's say it's for student loans or something, you know, and you think, and it looks legitimate, right? But you know you didn't ask for this email, and it looks good. It looks like something you'd buy. Wow, I'm in the market for a student loan. I'm going to click on it, and you go to it. You're in worse shape than if you just deleted it, just left it alone and searched on your own. Because what ends up happening is it gathers all your information. And sometimes it'll take you to some bogus student loan site, and you go, oh, this is garbage. Or it reroutes you to another site that's related to student loans. It lets you get some satisfaction out of it. But in the meantime, the site that it took you to has gathered your email address, your IP address, anything it could off of your system. And now you're going to get more junk mail after that. Because you're real. You have just validated yourself as being real. So some of them are good. They look good. In fact, there's one out for a university, actually, to get a degree. I keep getting that because they send it to all the EDU addresses. Because you know you're in education or you're a student. So go here, get an online degree at such and such, and it looks legitimate. Actually, it is for a legitimate. They used to do it for University of Phoenix a lot, too. It's a legitimate university. But when you click on the link, you don't go to that. Or you click on the picture, or apply now. You go somewhere else, which is not so good. So unless you ask for it, don't click on it. Just get rid of it. We know about spyware and adware and all that stuff. So adware generates ads, installs itself to download it from another program. Spyware, spy on, see what you're doing here. We don't need to know about this stuff. You guys know about Trojan horse software, perhaps. Install software you don't want inside your computer as well. Inside software that you do want. You have software that you don't want. Some of these detected. If you go online and search for, if you've never heard of any of this stuff, you're lucky. So, weblogs, also a big problem still. Weblogs are one line of information from every visitor to a website. Keeping track of information that's on your computer. Anonymous web browsing hides your identity to the websites itself. So, a lot of people, this doesn't apply because you install antivirus software, you install spyware. So throughout the last decade or so, these problems have gone away. So I shouldn't say they've gone away. You've been more protected. The level of protection has become adequate enough that if you're smart and you just keep yourself up to date, abide by all of the kind of best practices, you don't end up with problems. Still, you get problems though with if you go on to BitTorrents and stuff. A bunch of stuff gets installed on your computer. don't go to BitTorrents. Because while you have your open connection and while you're downloading something, you're getting other stuff too you never asked for that stays on there dormant for a while, and then it starts after a while. And a lot of them are new stuff, so it doesn't get caught by antivirus software, it doesn't get caught by anything. So you don't know what's going on your computer, but eventually it'll start running slower because someone's stealing your internet access. They've piggybacked on you or something. Or you just have something running in the background that keeps logging everything you're doing and sending it somewhere or something. See, privacy in government agencies. They have different databases of information people. You know, there's a couple websites probably still out there for the hoaxes and stuff to figure out, is this real, is this not real? A lot of the people still fall for this stuff, actually, the internet hoaxes, stuff like that, and the government keeps track of it. Actually, with the Patriot Act, the government's doing a lot now. The government's actually invading your privacy, but you signed for it, though. You voted it into as a law. You made it legal for them to invade. You made it legal for them to listen to all of your conversations and read all your email and do everything. But not you guys, but American citizens sign their life away without even knowing. Oh, we're gonna catch terrorists. I want to do that. It's almost as bad. It's almost as bad as those emails you get. Check here. I want to help terrorism. Okay. I'm giving away all my credit card information and all my personal information to the government so they can do with it whatever they want to do. And the Patriot Act has helped cut down a significant portion of drug dealing in the state of California. More power to them. They're using it to crack down on people because drug dealers still use the phone. They still call each other, usually by payphones and stuff, Hey, you want to buy this? Hey, you want to buy that? I'm selling this, I'm selling that. Oh, a bunch of illegal activity gets done on the telephone. And then before 9/11, before the whole Patriot Act thing that came into place, people got privacy on the phone. Now they don't have privacy on the phone, which is actually a good thing for bad thing for drug dealers, good thing for the government. So there was some good that came out of it. So government agencies storing personal information, law enforcement can do that, FBI can do that, electronic surveillance, NASA. We pretty much opened up the world. Which a lot of people are just now realizing, actually. So government agencies storing personal information, Census Bureau, major issues with privacy on the Census Bureau. Actually, for the longest time, and then they decided not to do it. So here's the situation, especially in San Jose, California. Lots of illegal aliens. It's no mystery. California has the biggest population of Hispanic illegal aliens. And Florida, California, Florida, the border countries. We're bordering Mexico. So we have, especially LA, tons of illegal aliens. So they go around door to door to do census because they need to figure out how many kids in this neighborhood are going to this public school. So they use the census information for that. So knock, knock, knock. How many people live in here? Nobody. Oh, just me. And you got like 5 families in the back room because they're all illegal and not being reported. And then they're sending their kids to schools, which is great. And the schools are letting them in. And then like about 10 years ago, 8 to 10 years ago, we decided we're not going to support them anymore. So you had to be a citizen to go to school. So they can't send in somebody illegal to kindergarten, first grade, second grade. Can't send your kids. If you're not here legally, you can't send your kids to school. Which passed, but nobody enforced it. And then they reversed it. So, well, that's not right. That's not fair. You're taking it on the kid because the parents are here illegally. So we're way too friendly with illegal aliens, especially from Mexico. But anyway, long story short, I'm not going to turn this into a political debate. But privacy with Census Bureau. So what ended up happening is we lost our funding. So then they decided, well, we can't count anymore. We can't count how many kids are in this neighborhood or going to this school and the population growth and the imbalance of funding that we get. So let's not use it anymore. So they stopped using it. Now they actually go and we figured out that we have more illegal aliens than we thought we had. Because now they're reporting themselves. So I was like, what? And then for the longest time they were making them legal because they knew they were here. They were here for over 10 years. Why aren't they just legal? So they were making identification cards for them and making them legal. The system is completely messed up. But long story short, there was issues of privacy with the Census Bureau because we needed to use the information to get the funding, and then when we took the privacy issue away, okay, well, so we're going to make it private now. Then we got more information. Now we have more information, and we're using it again to figure out how much funding we need for certain services. So, student loan services. Actually, you apply for a student loan if you're a U.S. citizen, and you apply for a student loan, you get into the system, which is actually a good thing. However, your information is not necessarily personal. Social Security Services, Department of Motor Vehicles. Department of Motor Vehicles is the one who's responsible for all the background check information on the internet. They've disclosed all of the information that is available. You know, you go to research somebody. If you've ever tried to, I've never tried to do this, and I have never ordered these reports, so I don't know what kind of quality they are. But apparently from my cyber stalking friends, you can go and you can order background checks for like $10 on the internet if you're trying to cyber stalk somebody. Well, you don't even have to. You can get that information for free. But if you're lazy and you don't want to search for it, you can pay $10 and you can get every address they live at, their telephone number, all this, where they work, how long they've been there, all this stuff is coming from the Department of Motor Vehicles. So it got into the system somehow. So the DMV did it. But there's no law. You signed up for a license, and on your license agreement when you signed up, you said the DMV may use your information because they send it state to state. You get caught in Texas for speeding, they call back to California, they have access to the information. It has to be available, otherwise the system doesn't work. So this happened back when they connected the system. Prior to that, it never was on the internet. Now it's all over the internet. So actually you could buy the DMV. I don't know if you could do it anymore. You used to be able to buy the DMV database if you're a company trying to market something. Well, that brings up another situation, but companies that try to sell products to other people, you know, they buy lists, mailing lists. What's that? Name, telephone number, address, age, demographics, how much you make, and then they send you junk mail or emails or something to try to sell you a product. So.
Like
AT&T does it all the time. Yeah. Laws on privacy. Here we go. And I think I'm looking at the clock here. Oh, I think I probably could finish this. Health Insurance Portability and Accountability Act. This is the biggest one. Protect personal health information. This made it illegal for them to store bad information about you and to make it available to the public, or make it available to the public even if it's good information, which is great. Except for if you're a Kaiser person and you sign on the dotted line, you just said, oh, I don't care about that anymore. So you can always, just because the laws exist doesn't mean you have to limit your exposure. You can open up the door and let everybody else see. Financial Services Modernization Act, protecting personal computer information. Security employees, attacks on information and computer resources come from inside and outside of the company, sometimes intentional, sometimes not. Employee misconduct is more costly than assaults from outside, actually. Employees have access to more information. They used to say a company's biggest security risk is its employees. It still is, actually, because the employees have access to everything, and it may not necessarily be intentional. Someone calls into the phone, hey, is Bob at lunch? Bob? You mean Bob Smith, the CEO? Oh yeah, he's at lunch. Is he at that restaurant he always goes to? Yeah, you answer all this information and then you figure out, oh, that person is stalking him, or that person is trying to sell him something, or which is a major privacy breach, but you don't know, you're just trying to be helpful. So who's committing fraud? 61% committed by men, 39% by women. I don't know if these are accurate. Well, they're accurate as of a couple of years, 2005, actually, so they're about 5 years old. Medium loss of fraud committed by women, 102,000. This might be that there's more men up in higher management, actually. And that's where you're going to get most of the trade secrets. So, security and outside threats. What do we got here? Hackers, computer viruses, worms, denial of service attacks. If this is brand new to you, go ahead and read it. But you guys are all graduate students, so I'm thinking that you have heard of this stuff before, especially if you're computer savvy. Hacker types. The white hat hackers, the black hat hackers. So a lot of this stuff is a bit dated at this time. We don't have as many hackers out there. It's not as glorified as it used to be. So You can read through this on your own. Computer viruses can't hurt your hardware. That's an interesting thing. Many hurt files only, software oriented. Some of them are application specific as well. Only hurts mail programs, email programs. How fast can a worm spread? The sapphire worm spread pretty fast, actually. In fact, there's games. A lot of the hackers actually were competing against each other to see how fast something could spread. So, in fact, you see it when a lot of the big service providers take their services down. Like AT&T or something like that. Hey, wait a minute, there's a virus. There's actually now cell phone viruses out now. So, well, this is the biggest thing. People are using tablets and cell phones. So why bother with computers anymore? Hit those devices. They don't have antivirus on them. So well, iOS is pretty safe though. And Android's pretty safe. So a lot of the platforms have security built into them to prevent the kind of virus attacks. Conflictor worms not intended to shut the systems down. Instead, they do things. Operating system is attacking. So what does the manager do? Well, update the operating system regularly. Get rid of the vulnerabilities. So security measures, I don't have to tell you if you're working in this area. You have to worry about antivirus software, firewalls. Encryption, public key, biometrics. Biometrics is pretty useful these days because it's definitely better than password protection. Although password protection is used all over the place, it's the weakest form of protection possible. But it's cheap, affordable, and it's around in everything. So risk management and assessment. If you're the manager, you're not going to protect everything. It's kind of like people who get multiple insurance policies when all they need is one. But you are going to take it into consideration what happens, identify a risk, what is going to be a problem if that actually happens, implement the measurement, monitor for it. Ask what could go wrong, what's likely to go wrong, and what are the consequences going to be. You do this with intellectual property as well as security. So I know I've been talking about multiple topics today. They're all interrelated in terms of how you're going to protect the organization, how you're going to protect the business. Risk management is probably where you're going to start for everything. Just say, hey, I invented this chair. How am I going to protect it? And then you go out there and go, oh, I need a patent on the chair. I wrote the source code. What am I going to do? Well, I'm going to get copyrighted. Or, and I'm going to trademark I in everything. I plus something, lowercase I, uppercase second character. Or, I like this little apple thing. It's an apple. People go, well, it's an apple. How can you copyright an apple? Well, it's a different apple. It's got a little bite taken out of it. It's got a little thing on the top. It turns into a trademark. And then you protect it. So management is responsible for what happens with servers, communication networks, workstations. So the greatest threat is from the internet, and without it, we have nothing to work with. We're on the internet regardless, so that's going to be the biggest threat. So, all right, well, this was an interesting lecture. Hopefully you enjoyed it. Next time you invent something new, think about, well, how am I going to protect it? Also think about how you're going to protect your computer system and the way that your employees are working and all of the different problems that could come out of it and stuff like that. And don't download pirated software or use the internet illegally or violate copyright infringement. Don't go to BitTorrents and see what's going on with that because you're going to download something you don't want. And remember ethics. Ethics are important. So anyway, hit a wide range of topics, and that is everything you ever wanted to know, hopefully, about protecting people and information. So. Next week, we move on to another topic. This is all the stuff that you can use for assignment number 3. Refresh your memory. Assignment number 3 asked you about, should a company patent this idea? What other things can they do? Well, it's lecture number 11, the information technology. Okay, see you next week.